Good morning. This is the time and place for zoning case hearings for May 13th, 2015. My name is Bradley Collin, and I will be conducting the hearing as a hearing officer. We have one case scheduled for today, and all the relevant exhibits are posted on the panel located directly behind me. If you wish to speak, please write your name and address on one of the speaker forms which have been provided by the front door and submit it to our planning assistant. I would like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded and are part of the public record. Notification of this hearing was accomplished by the use of public notices, which were mailed to property owners located within 500 feet, including occupants of the subject property, physically posted on the site in question, and placed in local newspaper. The hearing will proceed as follows. I will read the description of the application request. The staff will make a brief overview, give analysis, and give us a recommendation. The applicant will be asked to come forward, stating both name and address. Will be asked to present the case within a 15-minute time limit if needed. Others in support of or opposition to the application and interested parties will be asked to come forward to speak, again clearly stating both name and address within a 3-minute time limit. Lastly, if needed, the applicant will be given the opportunity to make closing comments in response to testimonies given by preceding speakers, and that will be a 5-minute time limit. The hearing will either be closed and the case taken under submission, or the decision may be made at today's hearing. The project that we have before us today is an application for a variance to construct a new single-family dwelling, attached 3-car garage. The applicant's requesting approval of the variance to allow the use of an existing driveway that is not completely located on the same lot as the required garage. The property is located in an R1R floor area ratio District 2 zone, located at 1680 Valley View Road. At this point, I'd like to have our case planner give his presentation.
Yes, Mr. Collin. This proposal relates to the proposed construction of a new house on a lot zoned R1R, floor area ratio District 2. The property, because of its steepness, cannot accommodate a code-compliant driveway. The property is a flag-shaped lot with a slope of 74%. There's an existing driveway that takes access further north of the subject property and serves a number of residential properties that are adjacent to the subject property. The zoning code requires that for a required garage, the required driveway serving that garage be located entirely on the same lot. Since this property is a flag-shaped lot, the access to the garage would be along the flag portion, the stem of the flag, which is too steep to provide for a code-compliant driveway. Since there's an existing driveway that crosses the subject property and that's code-compliant, the applicant has requested a variance to use that existing driveway to provide access, the required access to the proposed garage on the lot. Having said this, staff has prepared a negative declaration, and if the proposal is to be approved, if the variance is to be approved, the negative declaration must be adopted prior to approval of the variance. Staff has reviewed the entire application. Given the restrictions on the alternative driveway options, it is staff's assessment that all the required findings to support the variance can be made. Staff is recommending approval of the proposal of the variance, subject to a number of conditions, most of which are standard conditions. Should the variance be approved, the next step in order to develop the proposed house would be approval by the design review board. So the proposal, the entire project is still subject to approval by the design review board at a public meeting. Having said all this, I would like to conclude my staff presentation unless there are questions from the hearing officer or anybody else.
I do have, I guess, one question I can think of. Do we receive any significant comments that are out of the ordinary from any of the other departments, like engineering or building and safety, or relating to this project?
We didn't have any out of the ordinary comments. And the only comment or the only condition that we've inserted from planning is there's a recorded easement for the driveway. The applicant has already provided some documentation to that effect. We would like to be able to review that. If that easement needs to be modified, will require modification.
To include the new driveway or access from the subject house.
Right.
Okay,
so that's inserted as a condition which would be further investigated or looked into later on should the house or should there be an application for a building permit.
Okay. In addition, there was no comments from fire in terms of access from the existing driveway that they're there. They didn't have any concerns relating to that.
They were all standard conditions.
Okay. All right. Thank you.
You're welcome.
At this point, I'm going to open the public hearing. As of this point, I only have one speaker card. Is there anybody else in the audience that wishes to speak on the case? Okay, that's fine. If you change your mind, make sure you fill out one of these green cards and then hand it to our planning assistant. So I'm going to go ahead and open up the public hearing. Please state your name and address.
Good morning, Mr. Hearing Officer, Brad Collins and Chris Bagdakian and Ista Zati. My name is Edward Hagobian. My address is 220 South Kenwood Street, Suite 210, Glendale 91205. And I am the architect, designer, and applicant for this variance. I would like to go through the four findings of the variance. Then if you have any other questions, I will be glad to respond to those. So the first of the findings asks variance shall be, how will the strict application of the provisions of any such ordinance noted above result in practical difficulties or unnecessary hardship related to the property inconsistent with the general purpose and intent of the ordinance? The strict application of the provision of the ordinance would result in practical difficulties or unnecessary hardships inconsistent with the general purpose of the ordinance. The topography of the site is such that the differential in elevations from street to the top of the proposed building pad is in excess of 50 feet, and the slope of the driveway will exceed the current code standards, making it impossible to use. Since the stem of this flag lot is narrow, it's about 21 feet. If it was wider, maybe we could design a kind of winding driveway to go to the top of the pad where we want to build a house, but it's so narrow that's impossible to build a driveway there. So we have to use this existing driveway that an easement was, I believe, recorded many years ago for 5 lots, I believe. 1, 2, 3, 4, 5 lots, yes. So we'll use that existing driveway, which is very nicely paved and maintained now, to enter to the garage of this property. The second thing B is what exceptional circumstances or conditions apply to the property involved or to the intended use of development of the property that do not apply generally to other property in the same zone or neighborhood. The topography of the site is so significant at the frontage of the lot that it makes it unique, different type of property from the average R1R zoned lot of similar size. This is the same thing that I was explaining. There are lots that they have excessive slope, but they have a wide frontage, so they can design some kind of winding driveway, but this stem is only 20 feet. While there is an approved and recorded easement established and commonly used between other four properties for decades, also a part of that driveway is located on subject property, making this property unique, which is different than other properties. As a matter of fact, the very beginning of this driveway belongs to a property that is owned by the owner of this property, and the other, I would say, 1, 2, 3, 4 properties, they have to drive through a portion of this property, which is a driveway, a common driveway, to enter to their properties. Okay, I go to number C. Why will granting of the variance not be detrimental to the public welfare? Existing driveways, slope, width, and turning radius meets the minimum required and maximum allowed of current code, which is like maximum 20% or width of the driveway or turning radiuses. One driveway for 5 properties results in less grading and more landscape frontage. So if these 5 properties, each one they had somehow, of course it's not possible, they had their own driveways that will have less landscaping, more grading, more dirt hauling. Therefore, granting of the variance will be in keeping with the law, with the objectives of the applicable regulations. D. Why will granting of the variance be in keeping with the objectives of the ordinance? Granting of the variance will be in keeping with the objectives of the applicable regulations because of the significantly less grading for 5 lots, more landscaping in front of each lot, reduced slope of each driveway, making it safer. If the variance is not granted, the house should be built in front of the property with a minimum of 15 feet setback, and because of the narrow frontage, there will be no room to build a house beyond the side setback, because we have 21 feet width. If we take 10 feet and 10 feet side setbacks, we'll end up with 1 foot left for a house there. So it's also impossible to build a house in the front of this property, which is fronting the Valley View Road. Then we have statement of additional fact related to the variance request. If the variance is granted and the house is built there, there will be a property developed with more landscaping designed by a professional, safe and controlled irrigations. As other lots that they have view, sometimes people drive and come there and stop there to watch the view, and they don't behave properly, throw bottles or things like that. So anytime that something is built in a vacant lot like this, there is a more control, and that's another positive thing that will happen when this house is built. So I conclude my comments with these 4 findings. I can't think of anything else because Mr. Bagdikian had very nicely analyzed and commented on these 4 findings and the results of it. So I think I don't have anything to add to his comments.
Okay, thank you. I do have a question. Is this the last remaining parcel up there that has not been developed that will have access on that road? Or is there a possibility that other...
As far as I know, yes, that's the last one.
Okay. And there's no oak trees or sycamore trees or anything?
Not in this lot.
Okay.
It's not even at the 20 feet beyond of this property.
And the surrounding neighbors?
Yeah, there is a oak. There
I mean, in
are
terms
oak
of
trees.
just the project itself?
No, not in this project and 20 feet beyond.
Okay, and then the adjoining neighbors or neighbors that also have access from the same driveway?
Yes, all of
Are
them.
they aware of, I assume they're aware of the project, and none of them had any concerns about the use of or sharing the driveway?
As far as I know, nobody called us, nobody sent a letter to us, unless if they have contacted the city. That is something that I'm not aware of it.
Okay. All right. And do you understand and agree to the conditions of approval as recommended by
Yes.
staff?
Yes.
Okay, thank you.
Thank you.
Mr. Badikian, did we receive any phone calls, emails, or letters from any of the neighbors or occupants within 500 feet?
Mr. Cullen, we haven't received any letters. I just got one telephone call from one of the neighbors asking regarding the potential for any blockage of views. But that neighbor, I don't remember which one it was, but at the time I was having the phone conversation, I looked up the property, and the way it was situated, there was no issue with respect to views or any obstruction of views.
Based off of the proposed location of this house?
And the inquirer's
Location.
house location.
Okay, thank you.
You're welcome.
Thank you, sir.
Thank you.
I have no other speaker cards. I'm going to go ahead and close the public hearing. Based on the findings recommended by staff, the facts and information that have been presented at this hearing, as well as the input received from the other departments, I am going to adopt the negative declaration and go ahead and approve the variance per staff's draft findings and conditions of approval. So, after the hearing, the decision letter will be prepared in writing and will be in the form of a letter sent to the applicant and all persons who responded to the public notice, either by speaking at the hearing or by submitting written responses and provided their name and mailing address. The date of the decision will be the date appearing on the letter. Under the appeals provision of Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures on the procedures from Building and Safety, the Permit Service Center located on the same floor of this building. The hearing is now officially closed. I would like to thank everyone for coming. It is May 13th, 2013, and it's 9:53 a.m. Thank you all.